The decision has been a surprise as well as not a surprise. So Prince Harry breaks down after Meghan's ex suddenly exposes a hidden past that was never meant to be seen. Secrets, timelines, and quiet moments begin to raise serious questions about everything people thought they knew. What happened behind the scenes? Why is this coming out now? Join us as we uncover the truth. The situation grows more intense every day. Harry's shocking discovery. According to a security log obtained from a high-level source within the Personal Protection Officer detail, Harry did not confront his wife immediately. He remained in that study for 46 minutes, sitting in total darkness. The only light came from the scrolling pages of a document that revealed a life he did not recognize. One staff member, speaking under strict anonymity, described the atmosphere in the room as radioactive. The source recalls overhearing a muffled, agonized exchange through the heavy doors. Harry was heard whispering a single haunting question. Who exactly had he been living with for the last 8 years? At exactly 3 o'clock in the morning, the gates of the $14 million estate opened. Harry was seen behind the wheel of a black Range Rover driving with reckless intensity through the Santa Barbara hills. There was no security detail in the car. There was no destination, only the raw, unprocessed shock of a man who realized that the truth he had defended against the entire British monarchy might have been a carefully constructed Hollywood fiction. The core of this crisis traces back to Trevor Engels, the Hollywood producer, who was believed to be Meghan's first husband. For years, Engels was the man who knew too much and said too little. But something shifted in the final quarter of 2025. A series of legal depositions in a separate entertainment industry lawsuit triggered a disclosure requirement. Documents that were meant to remain sealed for 50 years suddenly became vulnerable. Among them were a 1999 record from a small municipality in the Caribbean and a series of medical and adoption records from Illinois that predated Meghan's rise to fame. The documents Harry viewed that night reportedly point to a devastating discrepancy. The allegation involves not only a secret marriage at the age of 19 to a man named Joseph Goldberg Giuliano, but also the existence of a child, a daughter born during Meghan's years at Northwestern University, who was placed for adoption before her Hollywood career began. The scale of this revelation is immense. Immediately after his midnight drive, Harry began taking action. By 8 o'clock that morning, a formal request for information was sent from Harry's private legal representatives to the United States Bureau of Diplomatic Security. This unit is responsible for vetting the background of spouses entering diplomatic circles. Harry was not asking for a public relations statement. He was requesting the Sun 160 form and the supplemental background checks completed during Meghan's visa applications in 2017 and 2018. He was searching for omissions. In the realm of international law, an omission on a visa document is not a minor error. It is a federal offense that can lead to the revocation of residency status. One close associate of the Duke of Sussex described his state as total identity collapse. Harry had built his post-royal brand on transparency. He wrote a 416-page memoir, Spare, to expose the secrets of his father and brother. Now he faced the reality that he might have been the one person kept in the dark. The associate recalled Harry's reaction later that day. He repeatedly checked the security logs, acknowledging that the institution he had opposed had been right to exercise caution. Harry realized he may have exposed his children to a minefield without knowing the layout. The timing of this revelation is catastrophic. It is now April 7, 2026. A major royal milestone is just weeks away. Harry has reportedly stopped speaking to the legal team he once shared with Meghan and has retained independent counsel. The unified front of the Sussexes has not just cracked. It has suffered a structural failure. As the sun rises over the Santa Barbara coastline, the question is not whether this story will break. It is how much of the original Prince Harry will remain once the full biography of Meghan Markle is finally officially and legally revealed. This unfolding situation continues to evolve. The second phase of the investigation promises to uncover even more documents, timelines, and records that may have remained hidden for decades. Each piece of evidence is critical. It is part of a larger picture that challenges what the public believed about Harry and Meghan. The scrutiny now extends far beyond personal or family matters. It intersects with international law, diplomatic processes, and the legal obligations of disclosure. The hidden timeline shaking the British monarchy. To understand the scale of the crisis currently shaking the British monarchy, It is essential to look beyond glossy magazine covers and carefully curated headlines. The public narrative has long presented a simple story. A young woman from the northwestern United States rises to become a Hollywood actress and eventually a duchess. Yet, the timeline now emerging reveals a far more complicated story. Years once thought ordinary are missing from public records, and files once assumed destroyed or irrelevant have resurfaced, showing a level of secrecy that shocks even the most seasoned observers. The earliest documented events trace back to September of 1999 in Evanston, Illinois. Meghan Markle enrolled at Northwestern University, stepping into the academic world with ambition. However, her school records alone do not tell the full story. Newly surfaced documents suggest she began an intense relationship at the time with a man identified as Joseph Goldberg Giuliano. This was no casual romance. Sources describe it as a connection that set the stage for future events that would later ripple through royal circles. A major anomaly appears in May of 2002. While the world assumed she was simply a struggling student focused on studies and early career ambitions, a civil marriage registration reportedly occurred on the island of Jamaica. It was quiet, private, and not celebrated publicly. Yet, legally, it was significant. Immediately after this registration, the record was sealed by a top-tier entertainment law firm in Los Angeles. This action was not ordinary. It was a deliberate, high-level effort to remove the record from public view. Questions naturally arise. How could a 21-year-old student secure the services of a firm charging $1,000 an hour to erase such a record? This question now occupies the minds of legal analysts within Buckingham Palace. From 2011 to 2013, the public was only aware of the marriage to Trevor Angleson. This relationship was presented as the only prior marriage. For more than a decade, it served as a screen, preventing deeper scrutiny and deflecting attention from earlier events. This carefully maintained narrative ensured that little investigation seemed necessary, allowing the past to remain obscured. In May of 2018, the world watched as Prince Harry publicly pledged his devotion at Windsor Castle. Millions around the globe witnessed what appeared to be an unwavering commitment. Yet, the royal vetting process, normally precise and thorough, relied on the declarations provided by the couple. It failed to detect the 2002 Jamaican marriage because those records had been legally moved into a private, non-archivable trust. The silence built into the system was finally broken in November of 2025. Trevor Angleson, under a mandatory subpoena for a high-stakes Hollywood film copyright deposition, was forced to disclose all previous legal obligations and dependents, releasing detailed records about the inner workings of the royal family. Under penalty of perjury, he could no longer withhold information. Details of a pre-2002 legal dependent leaked, eventually reaching investigators by the third week of January 2026. The fallout was immediate. Prince Harry realized this was more than a simple oversight. It was a carefully constructed concealment. Sources close to the Sussex household described the moment as a realization that the vetting process had been intentionally bypassed. The discovery became a breaking point, highlighting that the mechanisms of silence were deliberate and expertly executed. Today, April 8, 2026, the monarchy faces a turning point. An emergency session of the Royal Legal Advisory Council is underway. This is not a casual family discussion. The agenda is critical. The validity of vows made in 2018. If a spouse enters a royal marriage while concealing a previous legal union or the existence of a direct heir, the legal standing of their current title is at risk, creating a constitutional dilemma. The Council is now examining not just the possibility of divorce, but the potential declaration of nullity. Questions remain. What is in the 2002 Jamaican file? Why is the palace now reviewing adoption laws from Illinois? The timeline is no longer merely a sequence of dates. It has become a countdown to accountability and confession. Legal experts in Whitehall and Buckingham Palace are asking the same question. How could a firm succeed in hiding records for decades while MI5 and specialized vetting units failed to detect it? The answer is not simple negligence, but rather a masterful exercise of legal engineering. A loophole in the royal vetting system was exploited with surgical precision, leaving even Prince Harry vulnerable. Understanding this mechanism is essential to comprehending how the monarchy now faces one of its most complex and delicate crises in modern history. Gaps in a royal background check. In today's world where digital footprints are expected to reveal almost everything, Systems designed to verify personal histories are often seen as reliable and complete. This belief shaped the royal vetting process, which was meant to carefully review anyone entering the inner circle of the British royal family. However, documents linked to the Montecito study suggest that what appeared to be a complete background may not have been as full as expected. Instead of a fully detailed personal history, what was presented seemed carefully shaped and limited. The royal vetting process begins with a step known as voluntary disclosure. This stage depends on honesty and personal responsibility. When someone is preparing to join the royal family through marriage, they are expected to provide a full account of their past. This includes previous relationships, financial connections, and any legal unions. It is meant to be a clear and complete declaration given in good faith. The system relies heavily on the idea that the person involved will be truthful, especially under the weight and importance of such an institution. In the year 2017, Meghan Markle reportedly submitted her personal record as part of this process. According to reports, this record acknowledged only one past legal union, which was her divorce from Trevor Angleson. Within the structure of the British establishment, there is a strong belief in honor and integrity. When a declaration is made at this level, it is generally accepted as truthful, and the next steps are built upon that foundation. The second stage of the process is the public data cross-check. At this point, specialized units from MI5 and the Metropolitan Police begin their work. Their role is to verify the information that has been provided. They examine international marriage records, divorce documents, and civil court filings. This step is designed to catch any differences between what was declared and what exists in official records. Under normal conditions, this system is thorough and effective. However, in this case, the process may not have worked as intended. Reports suggest that those managing Meghan Markle's legal and public image understood how to work within the boundaries of the law in a very precise way. A key detail lies in the difference between a divorce and an annulment. While both relate to the end of a marriage, they are not the same in legal meaning. A divorce confirms that a marriage existed and has now ended. It leaves a clear record that can be found and verified. An annulment, also known as a declaration of nullity, works very differently. It states that the marriage is considered not to have existed at all in the eyes of the law. In simple terms, it removes the marriage from legal history. This creates a situation where there is no standard record to find. If such an annulment is handled in a private family court, especially in a place with strict privacy laws, the information becomes even harder to access. Locations like a specific parish in Jamaica or a small protected county in Illinois are often mentioned in this context. These jurisdictions can keep records sealed and out of public reach. When combined with the use of a top Hollywood law firm, these records can be further protected under a court-ordered non-disclosure agreement. This means the details are not only hidden but also legally restricted from being shared. By the time British security services carried out their checks in 2017, they were working with what was available in the public domain. What they found matched the information that had been declared. However, this information may have already been carefully shaped. The result was a profile that appeared complete, but was actually limited. It showed what could be seen, not everything that existed. This situation was not a typical background check. It became a meeting point between two very different systems. On one side was a traditional state intelligence structure built on trust, procedure, and established methods. On the other side was a modern, highly managed public image supported by expert legal and public relations teams. These teams were skilled in shaping how information appears and what remains hidden.